Do you mind if I put that shade down as the tab?
Certainly, I do a couple of those.
Thank you. Awesome.
I think so.
Okay.
Going back and make it easy when you don't have to leave.
Whenever you're ready, we'll.
I'm recording now.
Okay. Good morning, everyone. I'm calling the meeting to order. This is the February 4th, 2026 meeting of the Telecom Policy Committee. This meeting is being recorded and we are hybrid. We have people here on the campus at DPSST and online. And with that, I will read an announcement. The Telecom Policy Committee Administrative Announcement. This is a public meeting subject to public meeting law and it will be digitally recorded. Deliberations of issues will only be conducted by the Telecom Policy Committee members unless permitted by the chair. Remember to always state your name for the record. For cases dealing with denial or revocation, only information contained in the staff report can be considered once the staff report is adopted. Assumptions, outside knowledge, or personal experiences should not be included in any discussions. Individuals who engage in disruptive behavior that impedes official business will be asked to stop being disruptive or leave the meeting. Additional measures may be taken to have disruptive individuals removed if their continued presence poses a safety risk to the other persons in the room or makes it impossible to continue the meeting. Juan, would you take roll?
When I call on you, please state your name and who you represent for the record, and we'll start with you, Chair Fletcher.
Mike Fletcher, representing Oregon Apconina.
And then next up, we have Member Ash online.
Travis Ash, Baker County Sheriff for OSSA.
We cannot hear you.
Can you hear me now?
Yeah, no.
They can.
I can
okay.
hear
Hear me?
Oh, you can hear. You're perfect.
Hmm.
Yeah, that's odd. We'll continue. Chief Bell.
He put his in the chat.
He's here. He has no voice, so but he's there. So
I think the audio's on.
Okay.
So I'll have to message now.
He messaged in the chat.
And then next up, we have Member Hamilton. You're here.
Brandon Hamilton, Oregon Fire Chiefs Association.
And next up, Member Griffin.
Rhonda Griffin representing Apconina EMS.
Member Juarez.
Noah Wattis representing Telecom.
Oh,
Member Martin.
Greg Martin, public member.
Member Piercy.
Dave Piercy, Oregon State Police.
And next up, staff introductions. Juan Lopez, Executive Assistant, DPSST.
Melissa Lane Bacho, DPSST.
Daphne Calpine, DPSST.
Jennifer Howell, DPSST.
Ben Hamilton, DPSST.
Cindy Park, DPSST.
Kathy Fink, DPSST.
thank you. I am concerned, Juan, just because we can't hear the committee.
I just messaged them
Okay.
to come down. They can hear us.
Yeah,
And one more in the lobby too. One they just flashed up there.
And that's Member Fisher coming. Member Fisher, we're doing introductions. If you would like to state your name and who you represent for the record. Member Fisher, can you hear us? They can hear us, but
And they can hear each other.
and they can hear.
for the committee members online, we have tech support here. We're trying to fix the audio.
You know where Chief Bell is from?
They put this, let's plug it in this meeting and come back to it. Not yet, it's a different go. Then come back. Yeah. To all the members, we're going to have to exit the meeting and re-log in, so please sit tight. I'm gonna be able to hear this volume. Testing, you guys can still hear us?
Yes, I can hear you.
Can one of you guys say something? No sounds coming from the speakers. Not good. You've already left and rejoined it? Yeah. It's fine. Can people on Teams hear us?
Y'all are loud and
Okay,
clear.
interesting. But we just can't hear y'all on our side. Can someone just say something just for my own paranoia?
Yeah, can you hear us?
It's interesting. You already cycled.
Oh, something just perked.
It was looking fine on Monday. I feel like a little policy for this thing again. So if we want to just tell them we're right back again. To all the members, we are going to have to reboot our system, so we apologize for this delay and we will be back.
vote today. The department is seeking a vote to approve or return the cases for further review.
Thank you very much. So does the committee have any questions, or is there any discussion and or a recommendation for by consent to what are we doing here?
We're gonna vote.
It
Somebody
is, okay.
make a motion.
Okay, thank you. Looking for a motion.
Member Moore is here. I would move we accept the department's recommendation.
Okay, and thank you. And Chief Bell is a second. Any discussion? For the vote.
All right, we're voting to approve the administrative closures consent agenda as presented. Chair Bletcher,
Aye.
Member Ash.
Aye.
Member Bell. Member Fisher,
Aye.
Member Griffin,
Aye.
Member Hamilton,
Aye.
Member Juarez,
Aye.
Member Martin. Aye. And Member Piercy. Aye.
Thank you. At this time, we're moving to a professional standards case review. Again, Melissa.
Thank you. Melissa Lang-Botcher for the record. Chair and policy committee members, the department opened a professional standards case for Melina Edwards after she self-reported charges for driving under the influence of intoxicants and reckless driving. In the incident, which occurred on February 25th, 2024, Edwards was in her vehicle parked outside of the police station. When officers approached her, they could smell alcohol and asked Edwards to come into the police station to talk. Edwards reported that she was driving from her home to the police station at the time. She consented to field sobriety testing and submitted a breath sample, which reflected a blood alcohol content of 0.14%. In tribal court, she entered a plea of no contest to the charge of driving under the influence of intoxicants and was given a suspended sentence. The charge for reckless driving was dismissed. Edwards is seeking a return to employment, and the department found in the information moral fitness violations for misconduct, that Edwards violated criminal law and has a criminal disposition based on her plea of no contest for driving under the influence of intoxicants. And at the time, she was operating a motor vehicle while intoxicated, which threatened harm to persons or property. The department is seeking a disposition in the case from the committee. Mr. Chair.
Thank you very much. So assuming everybody heard that and has reviewed the case, I'm looking for a consent to adopt the record or return the case back to staff for additional information.
Martin, for the record, I make a motion that we go forward with it.
Okay, so we're looking for a consent. So for the committee to give a thumbs up for consent in the room, we have that. Very good. We can. The record is. I'm sorry. The report is adopted. So at this point, we're going to open up the case for discussion. We're discussing aggravating and mitigating factors. I'll remind the committee to state your name for the record.
Martin, for the record, for mitigating, I had that she was not employed at the time. So her actions didn't reflect on a specific organization. I thought it was real good that she self-reported to DPSST. So many of them don't. And reading through it, she cooperated with authorities, which was good. Aggravating, I got 0.14 blood alcohol level being almost twice the legal limit. And although it didn't reflect on an agency, she's seeking certification as a telecommunicator, and I think her actions reflected on the profession as a whole. And she had previously signed a code of ethics or code of conduct. Thank you.
Is there any other input? Hearing none.
Chief Bill.
Oh, thank you.
Read that, yeah. Mitigate.
Per Chief Bell in the record, mitigating cooperative with investigation and no dishonesty or effort to conceal the truth related to the unlawful conduct. Thank you, sir.
Have an aggravating factor.
Thank you, sir.
Dave Piercy, OSP, for the record, like probation for this incident was resolved or concluded as recently as June. That's very recent.
Any other input?
Well, Martin, for the record, I guess the flip side of what was just said is that she did complete it, correct? So that would be mitigating.
Brandon Hamilton for the record. Mitigating would be the fact for me is that we're almost 2 years removed from the incident. And there's been no other issues.
Thank you, sir. Let's see, you catching all that?
Yes. Are you ready for me to summarize what was
If
discussed?
there's any other input, I'll have Melissa read those back.
Great. I noted as mitigating that the committee identified that at the time of the incident, Edwards was not employed in public safety. She self-reported the incident to DPSST and cooperated in the criminal investigation. There was no effort on her behalf to conceal the truth and no indication that she was dishonest with law enforcement. She completed probation and there were no additional incidents of criminal activity. As aggravating, I have that her blood alcohol level was almost twice the legal limit. Her actions negatively reflected on the telecommunicator profession as a whole. And her probation completion date was recent in June of 2025. Mr. Chair.
Thank you. Looking for consensus of the committee members that the aggravating and mitigating circumstances or issues were recorded correctly. Did I miss anything?
Martin, for the record, I'd like to add mitigating that she completed. You had it as aggravating, but it's also
I'm
she
sorry.
completed the probation.
I did have down that you mentioned that that she completed probation. Sorry, I forgot to read
I
that.
guess all requirements, not just
Okay.
not just the probation.
Thank you. If the committee's satisfied with that, we'll call for a motion. I'm sorry, open the discussion whether there was a moral fitness violation. Again, remind members, following options for the moral fitness findings identified in the staff. So we're either going to affirm, accept as is, modify, make changes, or negate and remove all.
Martin, for the record, I move that we accept as is.
Affirm, accept as is. Okay, anybody have any other comments?
You need a second? This is Brandon. I'll second.
Somebody waves up there.
So we have a motion and a second.
We're voting to affirm the moral fitness violations as presented. Chair Fletcher?
Aye.
For Ash?
Aye.
Member Bell? Member Fisher?
Aye.
Member Griffin?
Aye.
Member Hamilton?
Aye.
Member Juarez?
Aye.
Member Martin?
Aye.
And Member Piercy? Aye. Motion carried.
Thank you. At this point, we're going to take a motion of whether to take action or no action.
Martin, for the record, I move that we take no action against certification.
We have a motion. Is there a second?
Member Morris has a question. Can I ask a question?
Yes, sir.
So I know we're hearing this case because she was with Warm Springs in Harney County and is wanting to come back into telecom. Were those not the circumstances? And this was, if she was trying to come into telecom, having not previously worked in the profession, this would have gone to the applicant review committee, is that correct?
I believe so.
And my question related to that, because we're coming up on the 2-year anniversary of the offense. So there is some recency there, but there is also some time. Does anyone there present know if this had come before the applicant review committee, what sort of a timeline they're looking at for findings of misconduct?
Melissa, are you able to answer that?
I'm not.
I'm happy to.
Okay.
Please.
All right.
Hi, Jennifer Howard for the record, Administrative Rules Coordinator. So while the applicant review committee reviews pre-employment criminal dispositions, so when the individual has no prior history working in public safety, their timelines when a person has engaged in gross misconduct is 0 days to 10 years from the date of the criminal disposition. But I do want to specify that that is a different lens because of the fact that they were never employed in public safety before. So the reason why this case is before you today is this person was previously employed in public safety and certified as a telecommunicator. Thank you. Yep.
Does that help you know?
Yeah, that does. I really appreciate it. Because I'm wanting to make sure that we're being consistent. And I remember just the last time we met, we had another review with a case of DUI. But in that case, we had the benefit of more than 20 years of time to go back and sort of reflect on the moral character. Whereas this, it didn't just happen, but it happened pretty recently. Anyway, I appreciate that, Jennifer. Thank you.
So we do have a motion on the table. We're looking for a second.
And okay, so pardon me, may I, for the record, Jennifer Howald, as also part of the motion, if there's an explanation as to why the motion. So we do like to capture for the record the reasons why the proposal is for no action.
Sure. And Martin, for the record, the reason I move that we take no action is simply because the mitigating factors outweighed the aggravating ones. I'll say again, she was not employed at the time and it doesn't reflect on her organization. She did self-report and she cooperated with authorities throughout the entire process.
We don't have a second. The motion dies. I'm sorry. Oh, Chief Bell, for the record, I agree, no action. Allow potential employee agency to consider facts in hiring process and background investigation. So that would be a second. So we have a motion, and a second. Is there any further discussion? Call for the vote.
All right, we're voting on a motion to take no action. Chair Fletcher,
Aye.
Member Ash,
Aye.
Member Bell, Member Fisher,
Aye.
Member Griffin,
Nay.
Member Hamilton,
Nay.
Member Morris,
Nay.
and Member Mark,
Aye.
and Member Piercy.
Okay.
Motion carried.
Thank you, everybody. And at this point, I guess we go back to Jennifer.
Thank you. Just a moment to organize my paper. I'm Jennifer Howell for the record. We're looking at agenda item number 5, proposed rule changes for Oregon Administrative Rules 259-008-005. And because there are 8 of them, I'm going to abbreviate and only refer to the last digits. 0290, 0300, 0310, 320, 0330, 0340, and 0400. So this is a set of administrative rules that helps guide the minimum standards for moral fitness. So the reasons why cases come before you as discretionary cases, as well as mandatory denial or revocation standards that DPSST administratively staff, as well as, so we have the standards within these rules, as well as the processes that the agency follows and the policy committee follows. So we, in 2023, formed the Criminal Justice Moral Fitness Work Group. It was a multidiscipline work group representing all of the telecommunications, the Corrections Policy Committee, which includes parole and probation, and the Police Policy Committee. Our own Rhonda Griffin was a member of the work group. So thank you so much for participating in that process, and feel free to add to any of the conversation today. So that work group started meeting in September 2023, met through 2004. We took a long break in 2025, large part due to the long legislative session that just took a lot of time and bandwidth for all members of the public safety community. And then we reconvened after that and got back together in October 2025 to round out the work of the work group. The work group examined those existing standards, discussed potential improvements, and considered draft rule changes. All of the meetings were recorded, posted to the DPSST YouTube page, and we have copies of the agendas, the memos, and the minutes posted on the DPSST rulemaking page. So today, your package includes the main memo, and that includes a summary of the recommended changes. The summary goes rule by rule and section by section through each of those. Attachment A provides tables that show you the side-by-side changes to the definitions of the moral fitness violations. So for the applicant review committee and those pre-employment cases that you see, those definitions are for dishonesty and gross misconduct. And then for the cases that the telecommunications policy committee sees through the discretionary cases, discretionary professional standards cases, those are dishonesty, misuse of authority, and misconduct. So those were all just provided in tables so you could see the current definition and the new definition kind of side by side, because it's hard to do that within the revised text. So attachment B, which is where we're going to focus today, going through and reviewing, is that complete proposed rule change, and it presents it with the sections that are inserted and the sections that are deleted. So it's a very long document with all of those revision markings. And because I want to recognize that it's a lot easier to read sometimes whenever it's just all said and done, attachment C was just a plain text version. So you could just read it beginning to end to see what it would look like as a final draft. I'm going to try to stay at an overview level. And I say that because I do tend to ramble. Feel free to stop me at any time to ask questions. If you want to look at something a little bit deeper, happy to go into that and provide any additional information at any time. So that said, starting with attachment B and the proposed rule changes, 259-008-005 is the rule that holds all of the definitions for the Division 8. Division 8 is all of the minimum standards for criminal justice public safety professionals. So the minimum employment standards, minimum training standards, the certification standards, it's the beginning to end process for all of those individuals. And so that's the definition, the rule that houses all the definitions that apply throughout. When we were working on revising the standards and processes, we realized that there were several paragraphs within the rule that were basically definitions. And this rule change proposes taking those items that are explanatory paragraphs and making them definitions in the definitions rule. thereby transferring that information. It will also help remove some of the duplication between Rule 290, which is the pre-employment standard, and the 300 and 310, which are the standards and the processes for the discretionary preference cases that you see. So with that broad overview, going through the rules through the definitions as they're presented, and the definitions rule is organized alphabetically. So you see we've moved aggravating circumstance, and at the end of it, you'll see that we moved mitigating circumstances as well. So taking that text out of the rule and putting it into definitions, and there were no significant changes to that. The next definition is criminal disposition. DPSST recommends amending criminal disposition to include suspended sentence and a deferred prosecution agreement, which are additional disposition outcomes that may not require an entered plea of guilt or a finding of guilt by the court. You can also see that we've taken the definition and reorganized it into a list for easier to read and easier to punctuate and to provide that. The next definition on page 3 is discharged. Discharged is a new definition. It adds interpretation focusing on the manner of separation from employment. And it does not include what is considered the for cause. The for cause portion of discharge for cause remains part of Rule 300. But this provides direction internally to staff so that we can clearly delineate between types of separations, which ones become mandatory and which ones become discretionary. The next definition is discriminatory conduct. Discriminatory conduct is a component of gross misconduct and misconduct as well as fitness violations. And this definition had been duplicated within each of those. So we're just relocating it into the definitions rule. And there were no significant changes to this definition. The next one is dishonesty, number 16 on page 3. Dishonesty transfers the definition, which is used in both Rule 290 and 300. It does include some revisions. First, the work group, through its discussions, recommended adding actions that conceal misconduct. And DPSST, through its review, recommends removing reckless disregard for the truth. And through the transfer, it has been rewritten, and it now says means intentional conduct that is untruthful, including dishonesty by omission, deception, misrepresentation, falsification, or concealment of misconduct. So it will hopefully be easier to apply because the very root of it is the intentional conduct that is untruthful. The including phrases help to expand on what may be considered untruthful, but it's not limited to that. So it's the intentional conduct that is untruthful would be the primary focus of the application of dishonesty. Okay. Moving on to gross misconduct. This one again is Rule 290, the Applicant Review Committee pre-employment definition, and it was transferred and we did not make changes to it. It continues to be provided in the list. Number 22, harm. Harm is a new definition and it carries over to page 4. It provides interpretation because the term is used in gross misconduct, misconduct, and within misuse of authority. So the work group asked for some consideration on what could consistently be considered harm. And that will also help provide some direction to staff. So you'll see there on page 4 that harm includes, or harm means physical injury as defined in ORS 161.015, emotional distress such as anguish, grief, fright, humiliation, or fury resulting from the conduct that's under review, loss of or damage to a person's property, or loss of a person's rights. So when we're looking at, so for example, if you go back to gross misconduct includes deliberate or reckless conduct that causes or could cause significant harm. So that's what we would be looking for. We'd be referring to that definition of harm.
Pardon for the record. You've got discrimination listed under gross misconduct. It's my understanding misconduct or gross misconduct only holds a 3 to 10 year, but discrimination is lifetime revocation. So how does that fit in with having a cap of 10 years on gross misconduct?
Certainly. We have delineated that in the administrative rule. It's either in 310 or 320. We'll see it here as we go through the process. But through the administrative rule writing process, when we adopted the definition of discriminatory conduct and made it part of misconduct and gross misconduct, let me separate that. For the applicant review committee and the definition of gross misconduct, it's still limited to the 0 days to 10 years. For the discretionary cases that the policy committees hear, they have had if it was misconduct that does not include discriminatory conduct, they had the 3 years to 10. And if the current standard, 3 years to 10, if the misconduct includes discriminatory conduct, it's the 3 years to lifetime. So we have that lined out as a current standard in the administrative rule.
Thank you. And the other question I had, you might be coming up on it next, I don't know, but we ran into it in CPC before where it was a contempt of court, where it's not really a crime, but it's moral fitness. Where does that fit in?
Thank you, Jennifer Howell, for the record. I'm not going to address contempt of court later on, so it's good to ask your question at any time. I think that we would truly have to look at that on a case-by-case basis, and that the policy committees have the opportunity to identify that as an aggravating circumstance. Yeah.
Thank you.
Yeah, especially when it's not at a criminal level. If it were a criminal citation, then it might then trigger the misconduct as a violation of criminal law.
Thank you.
Yep, absolutely.
I do have a question.
Yes.
Mike Fletcher for the record. On 0290, 12. The language here is talking about a waiver of mandatory standards that historically required denial, correct?
May I have you hold that question?
Okay,
Because I will go deeply into that.
thank you.
Yes.
I have a question.
Okay, yes. So let me continue on with the definitions before we jump into Rule 290,
Great.
if I may. Okay. But were there any questions on harm before I continue on through the rest of the definitions? Okay. It's just, it's a new one, so it's really important to capture that. Let me find my page order here for ineligibility. That was a transfer. Misconduct, definition number 31 on page 5. And it is primarily a transfer from Rule 300 to this definition rule. We did reorganize it. It was in paragraph form. We put it in list form so that those different components could be identifiable as individual components. You don't have to have all of them. Each one of them is a separate component. We did separate the conduct that causes or could have caused harm as its individual one, and move the impact to agencies as a separate one so that it's clearly delineated. And then we also reworded that impact to agencies. Misuse of authority is again transferred out of Rule 300, and it was significantly rewritten, hopefully to better represent the intent of the definition. A mitigating circumstance was the transfer, and that is all of the changes in the definitions rule, everything that was moved over, everything that was added to it. Okay.
Question.
Yes.
Dave Piercy for the record. In the redefinition or the updated definition of misconduct, I see A through D.
Yes.
And D being conduct that disrupts and negatively affects the operations of any agency. I don't see any reference and haven't seen any historical references to violations of oaths, which seem to be important throughout both the telecom and law enforcement and fire vocations. Do you think violation of oaths, well, has violation of oaths been considered in discussion? And if it has been, Does it need to be called out specifically, or would it fall under D as conduct that disrupts or negatively affects operations of an agency, or else?
Thank you. That's a very interesting question. I would say based on my history with the DPSST and these moral fitness cases, the focus on so the example of violating the code of ethics has typically been kept in the category of an aggravating circumstance. I don't think I have an articulate way to say right now why it wouldn't be a specific violation. I'd have to look into that further, but it's something that could definitely be discussed.
I'm just thinking that we, in the public safety sphere, most certifications require an oath because we take that seriously. And at least as long as I remember, prior to providing testimony in court, you take an oath to tell the truth. And I would expect that, I know that's true when you join the military. It just seems like public safety and service to the public rests on oaths. And I don't see any reference to oaths. So I would just like to submit that that should be something to at least consider when making these definitions.
Thank you. I'll note for the record that way may need a longer consideration than this rule change. So I might have to hang on to that as a suggestion that we research further and bring back.
And Captain McAlpine, for the record, it is noted many times, I think usually an agency writes up where they do put that as part of their justification for whatever action they take. So it is woven in there, but I think your point of calling out specifically as opposed to relying on the agencies to bring it up and interpret it somewhere in the conduct is noteworthy.
Comment to Melissa Langbacher for the record. When we do take action against an officer certification, we do specifically reference that it is a violation of the code of conduct, the moral fitness violations that have been identified by the committee. So interesting question, though.
I did recall one aspect. So if we're looking at the definition there of misconduct, and it currently has the 4 individual components, and any one of those can result in denial or revocation. If you added a standalone of the violation of the code of ethics, I think that it becomes a question on, would you revoke someone solely on just that single ground? And would it be enough to rise to that level? I think that has been part of the discussion in the past on whether or not there would be enough legal standing to that.
Dave Piercy, for the record, thank you for that commentary. I suspect that the threshold for some agencies would be to terminate for violations of the oath, of a oath. And I also could see oaths being considered as aggravating factors in the discussion of, taking action against somebody's credentials. So I don't see anything in this definition that would lead me to not be in favor of the update. I just think it's worthy of consideration. We actually refer to people in sworn positions as sworn because we place a lot of emphasis on the value of swearing to those oaths. And I just think that part of this organization, not just the committee or the other committees, but also the public safety standards and training mandate is to include the solemn, consideration of the solemn oaths that the different disciplines take.
No, I will be happy to research that further and come back to the committee later. Yep. Yeah. Okay, thank you very much. So now we will jump to page 9. And page 9 is Administrative Rule 25900800290, the denial of public safety professional certifications using those pre-employment standards that apply to the criminal dispositions. So just as a broad overview, throughout these rules, there have been some minor changes for clarity as well as word changes or structure changes that help things match our Oregon Revised Statute language and authority. So that's primarily what you see in 2 and a large part of 3. Chair Fletcher, you started to mention that 3 shows an exception here. So let me start with Section 3 maintains that the mandatory disqualifying convictions listed in Rule 300 still apply to the pre-employment convictions in this proposed rule change. We are introducing an opportunity for a limited exception, and I'm going to explain that in a further detail when we get to Section 12 of this rule. So, but I did want to recognize that the exception begins in 3 there, where we're saying if a person who falls into the pre-employment criminal disposition has something that is a conviction that falls under mandatory, right now the current standard is it's mandatory, it's denied, that's it. So we'll discuss a process where there might be a limited exception that applies. Okay. So in number 4, you can see that the changes there where we removed the definition language and left it just as the list of violations. In Section 5, the revisions there are what's left after we remove the carve out for the DUI diversions. So all DUI diversions are still eligible for review with this carve out. And that recognizes that even though they may have successfully diverted, they do have a criminal disposition. And the conduct involved still could contain dishonesty or gross misconduct. In Section 7, we've added the opportunity for staff to close cases that have been opened in error or in the event that an officer is deceased. So that is the language there in 7. Before we had to do the inquiry or the administrative closure process. So we just wanted to acknowledge that if something internally is opened in error, it can just be closed internally. Number 8 and number 9. So on your agenda today, you were, no, I'm thinking of the applicant review committee. Let me back up. So you all had recommended administrative closures. This is the rule for the applicant review committee. The applicant review committee currently receives what we call inquiry closures, where we've looked at the information, gathered it all, and tried to evaluate whether or not there's a moral fitness violation. And we've either found that there isn't a moral fitness violation or that it is beyond the 10 years that the applicant review committee has, or there's insufficient information, or maybe records have been expunged or sealed, so on and so forth. So those have always just gone as information to the applicant review committee. Sections 8 and 9 add the formal process for the applicant review committee to approve those, just like the policy committees approve administrative closures. So that's what's happening in 8 and 9. Section 11. Again, Section 11 shows the changes as a result of transferring the definitions for aggravating and mitigating circumstances and the ineligibility period to the definition rule, so that what looks like an insertion here is just relocation from the sections that were previously deleted. It's maintaining that the applicant review committee considers mitigating in every case that the person was not employed at the time when the conduct occurred, and that the public safety agency is hiring them has completed the background investigation. They're aware of the criminal background. E is just that ineligibility language range, the 0 to 10 years, that's relocated. It did not change. It remains 0 to 10 years. And then F is added, and it notes that when all moral fitness violations have been negated, the case is basically treated as an administrative closure. It ends at that particular point. Okay, so now to Section 12. Section 12 is outlining the criteria for a limited waiver of those mandatory convictions. Just to give you a benchmark, if we looked to Rule 300 and Section 2, the mandatory denial based on a conviction applies to felony convictions, convictions involving drugs, domestic violence, or abuse of a child, convictions for a bias or a hate crime, and convictions requiring registration as a sex offender. So those are all mandatory convictions. Within this pre-employment process, there's a waiver of the mandatory standards in a limited opportunity. It would apply to felonies that are not against a person. It would apply to drug-related convictions that are use or possession. So person felonies and drug-related convictions that are manufacturing, distribution, those would still remain mandatory. As well as all of the others, the domestic violence, abuse of a child, bias or hate crime, registration as a sex offender, those would all remain mandatory. So it's a very limited opportunity to request that waiver. The proposed rule change also requires that 10 years have to have passed since the completion of all court-ordered obligations. So that would include time spent as in custody and any parole or probation after. That would have to be all completed in 10 years since the date of that completion would have had to have passed. These waivers would be reviewed by the applicant review committee and either approved or denied. If the waiver is approved, the applicant would be approved for training and eligible for certification. If the waiver is denied, the applicant would be denied training and certification. And just like the current process, it would be that permanent lifetime ineligibility. Based on the definition of an applicant in the Rule 290, this means that it would apply only to people who have been hired in public safety. So the employer has taken a big chance and investment in this person as well, having reviewed their background and chosen to hire them. That's the overview of the process, but let's talk about questions and what that change might mean.
Mike Fletcher for the record. So first of all, this is amazing. Whole bunch of work has been done. And I want to make a note of that it was well done. I have a question about the waiver. And I'm just wondering, does this open a door for persons who went before the applicant review committee, either administratively denied, closed because of the requirements, or the case was adjudicated, but based on the old standards? Do those people now have an open door to come back in and say, I want a do-over?
That is a great question. Jennifer Howell, for the record, no. The agencies and the committee and board's findings and final orders remain in effect. So there is not an opportunity to come back. Though the rules in place at the time that the decision made stay. So this would be from the date, should it become approved and become a permanent rule change, it would apply to cases that are opened and individuals who are hired after that date.
My second question is, what is the estimated time that these changes would be in effect?
Oh, this is February. So the best case scenario,
I'm just thinking ahead.
sure, probably the best case scenario would be a June or July implementation.
Of this year.
And that would mean that that there are no public comments. And there are no additional questions or concerns by any of the committees. So we still have more to get through today with the Telecommunications Committee. Then the same presentation will be given to Corrections and Police later this month.
And this has all been reviewed by DOJ or anything?
It is in the process of having that substantive legal sufficiency review as well. Yeah.
Thank you.
Brandon Hamilton for the record. I just have a question. Curious what the motivation or the driver is for relaxing these standards.
For the potential waiver, I have two examples of past cases. that resulted in mandatory denial for individuals. And so many years ago, we had a telecommunicator who was hired. It was either a telecommunicator or emergency medical dispatcher, and I can't quite remember which one. But the basis for their denial was a felony DUI conviction in another state. Because that conviction, regardless of the fact that it was a DUI, because that conviction met the definition of a felony in our mandatory requirements, we had no opportunity to consider any aggravating mitigating circumstances. It was just a straight denial. The second one was a bit more recent, and it was an individual who was hired in the police discipline who had a conviction that involved drugs. The conviction happened, I don't know how long ago, but enough time had passed that that individual had been hired in another state and employed and worked as a police officer in that other state. But in coming to Oregon, because we have a mandatory I just realized something, but I'll finish. Because we have a mandatory requirement that a conviction involving drugs is a mandatory disqualifier, that person had to be mandatorily denied. I realize in saying that out loud that that person wouldn't have come to the applicant review committee and therefore wouldn't have been eligible for this waiver, but sorry.
That's the case I was thinking.
That's the case you were thinking about? Okay.
Yeah, Captain Calvin for the record.
So I realize that now is, so if that were the case, if we were talking about a person who had a drug conviction for use or possession that wasn't marijuana, because that's already discretionary, in another state more than 10 years ago, but they were never employed in public safety, that would be the reason why they would be considered through the waiver process as to whether or not they could or couldn't proceed, because they had never had that public safety nexus prior, and it had occurred at least more than 10 years ago. So this is why I get rambly. But that is the reason why we brought the question forward, and it's proposed. So it is a proposal.
Just concerned we're opening Pandora's box here, so.
Captain
What is
Calvin,
thought?
for the record, you know, the one case, the last one that Jennifer talked about, he, you know, appealed all the way up. And the ALJ was very, very uncomfortable, did not like the fact that there was no avenue to consider somebody who had been more than 10 years rehabilitating himself, which is what they wanted. No past, you know, lapses, was successful in a law enforcement career, but had chose to move his family here for family. And we had no option but to deny, mandatory deny. And the feedback from the ALJ was, you know, frustration, but the fact that it was so rigid and didn't reflect today's society. So that was one of the things. It wouldn't go through the arc, but it still was a challenge. Both, you know, it was upheld, but it was the feedback from the ALJ was considered as well for future.
Follow-up question?
Nope, I'm good.
Sure. No, I have a follow-up question.
Oh, okay.
And is it that the consideration is too broadly applied? In that, in looking at felonies, does it need to be further narrowed? Or is it just the general
I just have,
idea of
I
it?
have concern just about softening our approach on criminal convictions.
Warren, for the record, this is a standard. It's felony or not, you know, I don't see why the need for exceptions. That happened through the court process where they could have pled down to the lesser or something.
And Mike Fletcher, for the record, just another shout out, something that is long past due is emergency suspensions. That is, I'm very happy to see that.
Okay.
Thank you.
I'm going to talk about that too.
Okay.
So everybody else knows about it too. Okay. So we will add the discussion about the waiver to the collective comments received from the policy committees so that we can further determine whether or not to move forward with that process or not. Okay, so that takes care of Rule 290 and the pre-employment. And if there aren't any more questions about pre-employment, I'll move on to Rule 300. So 25900800300 are the grounds for denying, revoking, and emergency suspending public safety professional certifications. We've got, this is where those mandatory denial revocation standards are found. Again, those were the convictions and we reviewed those. Just making a note that on page 14, there is new language that applies to section B and the conviction involving an offense involving drugs. Just the distinction, it was a question and a conversation that we had in the work group. What happens if it's a DUI conviction? There's no record that that DUIs were ever intended to be automatic, mandatory, lifetime permanent disqualifiers without that discretionary process. So this language in A is distinguishing that because we want to recognize that intoxicants includes more than alcohol now. So as long as there aren't any other convictions for use, possession, distribution, or something to that effect, and it's just strictly the intoxicants, the influence of intoxicants, that would remain a discretionary case. So that's what that language is in that addition. The changes that you see within subsections C, D, E, and F, those are just changes that align with the statutory language within Oregon Revised Statute. I do want to look at G. G is a new addition. DPSST is recommending adding convictions for stalking. And that's specifically stalking as defined in ORS 163.732. If it happened in another state, it would have to be the statutory counterpart in another jurisdiction to our Oregon statute. This was a discussion that we had within the work group. It was asked to take a look at it. Should we add this or not? And there was not consensus on whether to add it. We've included it here. When we started with the work group, it had the language of the involving any offense, any offense involving. So it's been restructured and narrowed to be specific to the ORS citation. And then DPSST is further recommending including stalking convictions as a mandatory disqualifier, not only based on the type of conduct, but also in consideration for the impact it has on the person's ability to own or possess a firearm. And so that is why it's currently included for consideration. I wanted to pause and see if there are any questions about that new addition. Okay. Section H is the mandatory revocation for discharge for cause. Carries over to page 15. And so it pretty much stayed the same. What you see as an addition, G, H, and I on page 15, those are pulled directly from statute, and those were added by the legislature over the past couple of years. That was added specifically to police officers as listed in this administrative rule. This administrative rule applies to all public safety professionals. So if any public safety professional is discharged for cause, which is intentional conduct performed under the color of office, to engage in the abuse of lawful authority, it would still apply to all of the disciplines. In recognition that I is engaged in policing indicative of bias, and was not as broad as what we currently had, which was discrimination against a person, we've maintained that engaging in discriminatory conduct so that it applies to all of the disciplines, not just policing that involves bias or discrimination. Okay. 3, discretionary denial or revocation of public safety certifications. Primarily there on page 15, you're seeing the changes where we moved the definitions over to the definition rule. On page 16, B outlines when DPSST initiates a case. So traditionally, we do that when there's a criminal disposition, conduct that's related to an arrest, when there's a separation of employment, and the circumstances involve investigation, settlement and agreement, or allegations of misconduct. When a student has been dismissed from the academy for violations of the student conduct code, falsification. So what we're suggesting there is an addition which is conduct related to finding of contempt of court, violation of an extreme risk protection order, violation of a restraining order, or violation of a stalking protective order. So if we receive that information, it would be cause for DPSST to open a professional standards case to review for dishonesty, misuse of authority, or misconduct. Okay, so section 17 is the emergency suspension. There is a limited existing application of emergency suspension in the administrative rule, and that would be if a case were to come before you. You could also recommend emergency suspension, which would immediately suspend the officer's certification while we're continuing through the rest of the process, the board approval, contested cases, anything like that. Immediately suspending a certification means that the individual can no longer perform the duties of. So the employer would have to give them a different assignment. They couldn't act as a public safety professional. Okay. DPSST recommends adding an option to issue an emergency suspension order when a public safety professional is charged with a felony. So this is before the normal time that we would be looking at a case, which is at the final end of it. This is at the beginning when the individual has been charged with a felony. The draft rule language identifies potential risk to public safety, and based on the feedback from the work group, adds a process for the executive committee of the board to review the charge and determine, based on the information that's available at the time, if the emergency suspension order is needed to preserve public safety. It says regardless of their employment status, which would include whether the person is currently employed, whether they're on leave or whether they're not employed. And in part, this is to recognize that there are times when even if the employing agency has put the person on an administrative leave, when you look at the records that DPSST holds, it still shows that they're employed and certified. And that can be challenging, for the public to look and see that someone's employed and certified, knowing that they've been charged, because it's an article in the newspaper, that they've been charged with a very egregious crime, or maybe even they could be even in custody at the time. So those were some of the reasons why the emergency suspension updates were brought forward for consideration. But happy to take any questions on the information or the process that's proposed.
Martin, for the record, I'm still kind of stuck on one. You mentioned violation of a stalking order.
Okay.
But the one I was thinking about earlier, the contempt of court, was violation of a no contact order. That seems real similar to me.
Let me go back a page. Okay, so on page 16, Cause for DPSST to open a professional standards case. The new addition is conduct related to finding of contempt of court, violation of extreme risk protection order, violation of restraining order, or violation of a stock protective order.
I thought I'd read that. Thank you.
So yes, we'll have to go back to your question. And I may have forgotten that it included contempt of court here, but the current standard is that it isn't a trigger alone, and it can be considered an aggravating circumstance. So it is not part of the definition of misconduct. That was your original question. Yes. So your original question is contempt of court misconduct. And so while it's not on its own misconduct, it would now, through this addition, be a reason why DPSST would look into a professional standards case. So it would give grounds to open the case, to review, to find out if the case in totality includes dishonesty, misuse of authority, or misconduct.
Thank you.
Thank you. It's a good clarifying question. Okay. And no further discussion about emergency suspension? Okay. So that wraps up Administrative Rule 300, and we can look at Rule 310, which is on page 18. I finished turning all my pages. Okay, so Rule 310 is the review process of professional standards cases. It really outlines the processes for staff as well as the committee review. I want to note that the deleted section 4 is again removing the carve out for dismissed DUIs. The new section 4 is adding again that language directing DPSST to close the case if it was opened in error or the individual is deceased. 5, 6, and 9 on pages 18 and 19 are just process clarifying changes, just small edits. So we'd be looking at 20, section 10, the policy committee review process. 10A, DPSST added language providing interpretation for a phrase that is contained in statute, which is that the policy committee and the relevant discipline and the board shall review the discretionary cases. So we've just outlined an administrative rule, what it means to be the relevant discipline and how that is determined. It usually seems pretty obvious on its face, but every once in a while there's a complex twist. So this just helps make it easy for all of our future selves. Okay, B, the committee will review the professional standards case too. So the changes here in B are primarily the result of consolidating the rule after transferring those definitions for aggravating and mitigating circumstances and ineligibility periods. At the top of 21, you will see where we've relocated the ineligibility period ranges. These ranges now also include some recommended changes to the minimum and maximum. So the updated ranges reduced the minimum from 3 years to 0 days and increased the maximum that would apply to misconduct or misuse of authority, and specifically misconduct that doesn't involve the discriminatory conduct, from 10 years to up to 20 years. So the discussion and the feedback from the work group was to expand our 3 to 10 years to 0 to 20. I'm happy to take any questions on those ranges if anyone had
Yeah,
questions.
Martin, for the record, so does that mean that the lifetime one is also 0 to lifetime?
Correct. We added section C that just notes what process takes place when the policy committee negates moral fitness violations. It becomes that committee's disposition that there were no such violations and no basis to deny or revoke, and that's the recommendation that becomes submitted to the board for approval. So just noting that, which is our current practice, it just puts it into administrative rule, so we don't overlook it in the future. The rest of the changes in Rule 310 are just clarifying edits. Happy to take any questions about them, but otherwise would move on to Rule 320. Okay. In Rule 320, DPSST added language that recognizes emergency suspension processes for, and then that's section 2 and section 5. We included clarifying revisions for interpretation and application of the start date of the ineligibility period. There are no changes to how we apply the start date of the ineligibility period, just hopefully trying to make it more clear, concise language. We did the same thing in section 6 on the eligibility to reapply, just hoping to make it a more direct process statement. In Rule 330, the surrendering certifications, a minor technical edit. In Rule 340, notice of intent to request a hearing or the contested case process. We didn't have any work group discussions on any part of this, but DPSST is including the rule for a minor edit that includes process for denial of training, which is better alignment with our statutory authority language. So that takes us to Rule 400. I need to take a breath because Rule 400 is about complaints, and that's going to be a big review process. Okay. Any questions about the standards or processes before we talk about the complaints?
Martin, for the record, one more. I don't remember seeing anything in the definitions that tells us the difference between a revocation and a suspension.
Sure. Right now, so a revocation is a permanent action against a certification. When the certification is revoked, it goes away forever. There's also, after that action, the committees recommend, when it's a discretionary case, an ineligibility period. And that ineligibility period tells us how long that person has to wait before they can come back into the profession and reapply for certification. A suspension. Right now, the committees and the boards do not exercise suspension authority to temporarily suspend unless we're looking at the emergency suspension process. So there's the emergency suspension process that is an immediate effective order, and it hasn't been exercised yet. So the expanded language may result in more emergency suspension, but it isn't something that has been exercised yet. There was a time period a few years ago where we did have suspension, but it was determined that it wasn't working out the way that it was intended, so they removed it. So we just have either denying someone's training and certification or revoking the certification that they currently have.
Thank you.
Yeah. Yep. Okay. So now I'm going to talk about Rule 400, which is the DPSST review of complaints that are submitted to DPSST against public safety officers. In this one, DPSST is presenting this rule change as a rewrite. So that means completely deleting the text and rewriting it. The addition of, we've included definitions, and the rewrite of sections 2 through 5 are intended to improve the readability and provide more process information when members of the public are reviewing this rule. In sections 4 and 5, DPSST continues to defer investigation of complaints to the employing agency. So that's the current practice. If we receive a jurisdictional complaint, it is forwarded to the employing agency. The employing agency reviews and determines what actions are taken. The changes that are shown in the rule here are changes to the agency response requirements. And these changes are based on recommendations that are found in the 2021 Secretary of State audit. The audit findings recommended that DPSST require agencies to include a brief synopsis of what they did with the complaint when it was forwarded by DPSST. So the synopsis would include whether or not there was an investigation, whether the allegations were sustained, and whether any discipline was imposed. The work group reviewed the Secretary of State audit recommendations and recommended that DPSST implement the changes to the agency reporting requirements per that audit guidance. And so that's what's currently in section 5 there. In section 6, DPSST maintains discretionary ability to review complaints under specified circumstances. So under our current complaint process, DPSST has the ability to further review complaints when the employing agency is non-responsive. They haven't said, yes, we've received your complaint, we've looked into it, we've handled it in the manner that we see fit. When the complaint is against someone who's not currently employed, or when the complaint is against an elected official. So those are the 3 instances where DPSST would proceed forward with a complaint. Those are maintained. We would still have that opportunity. What is updated is that in section 7, the work group recommended, so what we would normally do is we would take that information, we would share the complaints with the subject of the complaint, give them an opportunity to provide their mitigation, look through that, determine whether it could be closed. If we didn't find that it could be closed, then it would be submitted to a policy committee to review, to then tell DPSST whether there needed to be a professional standards case or not. So the work group recommended that we change that process and do the information collection on the front end. So that's where you see the section 7 updates DPSST process to collect documentation or records that are related to the complaint before determining whether or not the complaint needs to go to the policy committee. 8 clarifies DPSST discretionary authority to close the complaint if the review of the mitigation, the documentation, and the records show that there isn't substantial evidence of a violation of moral fitness standards. And then 9 and 10 update the committee review process to follow the same steps as a discretionary professional standards case. Because now DPSST would be collecting all of the records on the front end. And if there is substantial evidence to move forward, would then be able to present that from the beginning as a professional standards case to the committee for review. So those are the changes to complaints. I'm happy to take any questions. Okay. Bear with me for just a little bit longer. I want to tell you about the fiscal impact statement, and then it will be ready for your final review and recommendation vote. When you do a proposed rule change, you have to include information about potential fiscal impacts of that administrative rule change. So what we recognize first is that denial and revocation standards have existed for a long time. So there's already what I like to refer to as a pre-existing fiscal impact. If you become subject to these administrative rules, if you've violated the standards, there is a potential fiscal impact on your livelihood, as well as the employing agency and their staffing and so on and so forth. If DPSST, our caseload, our staff, our DOJ cost, there are pre-existing fiscal impacts, right? So the question becomes, do these rule changes affect what currently exists as a fiscal impact? And the basic answer to that is we really don't know. And there's not necessarily a way to measure that because it only goes into effect when somebody has it. Yeah.
Martin, for the record, well, we do know we're gonna have to reprint everything. There's a cost for that.
Thank you. We typically, it can be a case for individuals who do use print records, but for the most part, we don't have to reprint or redistribute anything. So the Secretary of State maintains the record electronically. So it's always available. The rule changes are always available online at any time. So we don't have printed publications that we have to redistribute. Yeah. I did identify 3 of the changes that could increase or potentially affect more individuals as part of the fiscal impact statements. Notably, DUI deferred cases. So when those DUIs were diverted and they were the only charge, they previously were administratively closed. DPSSC did not look at that conduct. We've removed that carve out. So that means that any individual in those matching circumstances in the future, we're not going to go back and look at old cases. I want to make that clear. We're not going back and looking at old cases, but if those circumstances occur in the future, those individuals will be subject to review. So there's an increase in potentially affected individuals there. The second changes were those changes to the emergency suspension authority and process. So that would definitely be a new fiscal impact for anyone who becomes subject to the emergency suspension process. And then the third area were those changes to the ranges in the ineligibility period. So there's positive and negative, right? We decreased the minimum from 3 to 0, so that could positively affect the outcome for someone. Whereas the increase from 10 years to 20 years could negatively impact. So those were the areas that we could identify as potential fiscal changes to existing conditions. Happy to answer any questions about that. Otherwise, I'm happy to take you to page 10 of your memo where the DPSST recommendation is to approve the proposed rule changes for 259-008-005, 290, 300, 310, 320, 330, 340, and 400. What your approval today will do is it will, we would then, of course, we're still going to go to the corrections and the police policy committee. So after each of those committees, our goal is to file the proposed rule changes so that we can collect the public comment. And so we would take any comment from the committees, any comment from the public, package those up for additional consideration. And so if there are if there are comments, then we would bring those back for further review. If there aren't, then we would move the recommendations onto the board for approval. So you have 2 action items. The first is consensus, which is approving the fiscal impact statements as presented in the memo or providing any additional changes or feedback. The second one is the vote, which is the motion and the second on whether or not to approve the proposed rule changes as presented. So I will note for the record the discussion on the waivers as Telecommunications Policy Committee feedback on the proposed rule changes. So that would be a comment that we would consider.
Good.
And then I have the separate action item to follow up on later with the violation of oath, violation of code of conduct. But I would package that one up as a separate one from this. Thank you. Any questions?
Thank you. Any questions or input from the committee? It was a lot.
Member Morris has questions. Although I had several on the front end and you answered most of them as you continued, so thank you. I appreciate that. Just briefly, I just want to express my gratitude for the proposed changes to the ineligibility period. I know that's been a source of frustration for me during my brief period on this committee. So I'm looking forward to that change. And then I have 2 questions. One is regarding emergency suspensions, which I'm grateful for that proposed language as well. The board that would have to approve those suspensions, how often does it meet? Because I'm curious about the emergency aspect of this. is it something where the board would take it up quarterly? So emergency would mean 3 months, maybe 4 months out from someone being arrested for a felony?
Thank you, Member Morris. Jennifer Howard for the record. The executive committee of the board is made up of each of the chairs of the committees. So that is the chair of the board, the chair of telecommunications, chair of corrections, chair of police, chair of fire, and chair of private security. So 5 to 6 members, depending upon who is the chair of the board at the time. It exists to address immediate and emergent issues that arise between board meetings. So in the event that we do have a cause to bring a professional standards case forward for an emergency suspension, it would be a special meeting of that executive committee and hopefully be able to be arranged within a short time period, like with, so we do not have to wait on the quarterly basis. It would be an as needed review.
Okay, thank you for that. That was my assumption, but I didn't want to assume. And then assuming these proposed changes are approved by all the individual committees, and then the board, do they go into effect immediately? Is there another step following that before they become active?
Sure. So after policy committees, we have the public comment period. And so it will all depend on the additional comments from the other committees and any public comments that we received. Typically, the rules go into effect after the board approves them. We don't submit them to the board until we've considered the public comments and made reconciliations after that. Sometimes we're able to do that internally as staff and include the recommendation to the board when the adjustment is made. Sometimes it requires going back to the work group to get their feedback before coming back to the policy committee for reapproval. So it just kind of fluctuates, but we can provide updates at each of the subsequent committee meetings to let you know where we are in the process. As well as before we, once the effective date is determined, we can do the constituent outreach and provide the updates and the notices to all of the agencies through the Gov delivery system as an announcement as to when that the board has approved them and that they will go into effect on such and such date.
Okay, I appreciate that. Thank you.
Any other input or questions? Hearing none, at this point, what we're going to do is we're seeking a consensus to approve or amend the fiscal impact statements that was presented to us. Approve. See thumbs up in the room. Thumbs up online. Thank you very much. We have consensus. The next is I'm looking for a motion to approve the proposed rule changes for OAR 259-008-005, 0290, 300, 310, 320, 330, 340, and 400.
Motion to approve.
I have a motion to approve as
I'll second.
presented and a second. Is there any further discussion? Hearing none. Juan?
All right, we're voting to approve the proposed rule changes for Oregon Administrative Rules 259008 with serial endings 0005, 0290, 0300, 0310, 0320, 0330, 0340, and 0400 as presented. Chair Fletcher.
Aye.
Member Ash.
Aye.
Member Bell.
Thumbs up.
Member Fisher.
Aye.
Member Griffin.
Aye.
Member Hamilton.
Nay.
Member Morris.
Aye.
Member Martin.
Aye.
Aye.
Motion carried.
Thank you very much. Kathy McAlpine will be doing agency updates, I bet.
Thank you, Chair. I'm going to be very short and sweet since you just had a pretty long discussion on all the rule changes. At this time, on behalf of PSST and the board, I would just like to recognize Chief Bell for his 3 years of serving on TPC, coming up on your pending retirement. But I know that when I was in the Professional Standards Division Director, Chief, I really appreciated your service, but also your comments and engagement that you provided over the last 3 years. So we do have a plaque and everything that Juan will email to you. But Chief, thank you very much for your dedication and your pending retirement. Appreciate that. And with that, I've checked with all the other staff. We have no further updates at this time.
Thank you very much. Congratulations, Chief. Thanks for your service with us. With that, if there's no other good of the order information, next meeting is May 6th, 9 a.m., same bat channel.
Thank you.